Well, welcome back to the TuckerAllen Virtual Town Hall. I'm Scott Trout, and as usual, I'll be your moderator for today, like I am the moderator for our Facebook Live chat that we do every Friday at 1 o'clock. If you haven't tuned into our Facebook Live segment, where we just take 15 minutes and we talk about some of the latest things in estate and planning and elder law, make sure to tune into that every Friday, 1 o'clock on the TuckerAllen Facebook page. You can check that out. But today, we're going to spend the next hour talking about something very unique. And when I first read it as the moderator, which is preparing your digital life for death, I got confused. Well, we're going to bring some clarity to those of you that are joining and watching. We'll talk a little bit about it. And as I read through it and off camera, I talked to our panel of attorneys. It really became something like an aha moment, became interesting. And now I'm really intrigued. And now I've got to go back to planning. Like the last time we joined, we talked a lot about Go packets and things that I had some homework to do, so I know you will as well. So get some pen and paper out and start taking some notes. Keep in mind that we don't want to make sure that this isn't legal advice to you. Everyone has a particular unique circumstance and facts, and your case, your facts, your state, yours is very unique and would likely require something different. But this is really for educational, informational. We want to get you in the right direction, and more importantly, we want you to take action. Regardless if it's with TuckerAllen, make sure to find someone who practices exclusively in the area of estate planning. If you want to get more information about TuckerAllen, you can go to the website at TuckerAllen.com, or you can give them a call at 866-335-3375. And you can have a consult via Zoom, in person, or even on the phone, just to get more information. So check that out. As we progress through our topic today, as we do with each virtual town hall, we set aside some time for some questions where you can submit them via the Q&A section or in the chat box. Check that out right now. Prepare yourself. Go ahead and submit a question. We'll get to those and sometime in the second half of our presentation today. We've got some questions that have already come in, and we'll be addressing those again in the second half. You can submit those in the Q&A section or the chat box, or you can go to the website at tuckerallen.com/questions, and you can submit those and we'll address those at future, even the Facebook Live, where you can tune in. We can get those as well. So make sure to check that out. But stick around. We're going to talk about the first half and preparing your digital life for death. We're going to talk a little bit about that, but let's go ahead and remind you to check out on the website at TuckerAllen.com that we're going to be hosting two seminars, one in the St. Louis metropolitan area in person, and that will be on Tuesday, November 24th at 1 p.m. And the great thing is that the room will be completely sanitized. You can attend with confidence. You can make sure that we're going to be minimizing the number of attendees. If you want to come in person, having masks, sanitization throughout the room, we're going to make it completely CDC compliant. For those of you in the Kansas City metropolitan area, we're going to be doing it at 2:30 using Zoom, just like this. So you can go ahead and join via Zoom on a seminar coming up. Check that out for more information, and more importantly, because space is limited in the St. Louis metropolitan area, you want to go ahead and register now. So go to TuckerAllen.com and you can check out more information about the seminars coming up on Tuesday, November 24th, and you'll get more information. So let's go ahead and introduce our panelists for today who are rejoining us from the offices of TuckerAllen. Let's start with Missy Manning in our Kirkwood, St. Louis metropolitan area. Welcome, Missy.
Hi, Scott. As you said, my name is Missy Manning, and I practice out of our St. Charles and our Kirkwood location. I'm certified in Missouri.
Thanks, Missy. Let's go to our Illinois metropolitan area office. Teresa Yao. Welcome, Teresa.
Thanks for having me, Scott. Yes, my name is Teresa, and I am licensed in Missouri and Illinois, which means I practice out of our Kirkwood office and our Edwardsville office.
And rounding out our panel for today, in the Kansas City metropolitan area, including over in the Kansas side, we've got Kevin Mason. Welcome.
Hi, Scott. It's great to see you again. As you said, my name's Kevin, and I practice here out of our Independence office.
Great. Thanks, Kevin. Well, as I suggested earlier, make sure to submit your questions right now in the Q&A section or in the chat box. We'll address those, and you can just toss those out, and we'll toss them to our panel. Hopefully get to those in the second part of our virtual town hall. So if you don't want to submit those now, you can submit those at TuckerAllen.com/questions. And we'll get to those in our Facebook Live segment every week at 1 o'clock Central Time. Make sure to follow the TuckerAllen Facebook page and check us out when we go live for 15 minutes. We'll just talk about one small segment of estate planning and elder law. Let's get started soon, but first, let's go to a real quick break, and we'll be right back.
I wasn't really avoiding it, but I'm pretty good at procrastinating. I needed a trust. When I found TuckerAllen, all our questions were answered, all of our fears allayed.
You want your wishes in place, so there's no guessing, no stress on the children.
Basically, they talk about what you need, what's important to you. It was more conversational, really very simple.
All right, welcome back. So let's get started to talk about the topic, which is preparing your digital life for death. And I know it sounded complicated to me when I first read it, and I was kind of getting ready to moderate the TuckerAllen attorneys. I had no idea what it meant. I was confused, but now as I read through it, and I know we'll bring some clarity to it, and it is so intriguing and really makes you think about how perhaps unprepared you are on the digital side of estate planning, things that I didn't even think about. And I know we're going to talk about getting to things like your Facebook page, getting to airline points, things that I didn't even think about. So let's start with Kevin. Kevin, kind of let's start at the top. What is digital estate planning? Kind of break it down for people as we start through this topic.
Sure. So just in kind of the broad strokes of what this is, digital estate planning would be just the process of organizing all of your digital property and making arrangements for that property after your death. So it obviously gets more nuanced as you would get into the different types of digital assets that you would have, whether it was a social media account or a bank account, but just in a broad sense, that's what digital estate planning is.
Yeah, I mean, it's everything as you think about it in this age, 25 years ago, and I'm not that old, but I'm older than all of you. And that is, we didn't think about it, right? And digital was really not something we had to be concerned about. And, there was a time when we couldn't access our bank accounts digitally. We couldn't get on there wasn't internet back when, when I was in school. And so that's what's really important and really key is to think about it. We all in some way, in some fashion, participate. We all now, everyone watching right now, we're using digital. And so why does it matter, Missy? I'm going to go to you. Why does this matter to the average person?
Well, there's a lot of stuff out there, even if you're not a super big computer person. So there's things like family photos that can be extremely sentimental to your family members after you pass away. And then, like you mentioned, there are things like bank accounts where actual money's out there that needs to be taken care of as well.
Credit card. I talked about credit card miles and airline miles are the points that you accumulate. The things that, perhaps we all think about, I want to title my car. I want to title my house. I want to do a TOD or transfer on death on bank accounts or something like that. But we forget what happens, with those items. I mean, I assume that's what we're talking about here, the points, the miles, the things that are accumulated that if for some reason, now with the pandemic, we've got COVID-19 hanging over our heads and things happen out of the blue, I guess that's something we should be concerned about.
Absolutely, Scott. So there's quite a bit of money out there as well. So I don't know if you're like me and you bank your credit card miles, your credit card points, but if something happens to you, that's actually quite a bit of money that's out there that your family may not be able to access without proper planning.
Yeah. Nowadays, and I was very intrigued, about a month ago, I was having dinner with an individual who has this blog, and she is a very successful blogger when it comes to fashion. And I had never realized how much money there is in blogging and prospectively, or I guess you could go through it. And I guess amount of the money that she has that's sitting, perhaps it's in Venmo, perhaps it's in PayPal. And that's how the transactions, I assume now that we're talking about those items as well, right?
Correct. So actually, I started my own online business to put myself through law school back in the day. So I'm very familiar with all of that sort of stuff as well. So if there's a blog, if there's a website with advertising money coming in, or if there's an online business, those are extremely important things to get in order. I cannot stress enough how difficult it is to go through probate with an income producing asset like that. So you want to make certain that things are in an LLC or something along those lines, and that people can access those accounts and know what's going in and out. So that way, if something happens to you, they can finish out the orders, close out the website, or continue to run that business. However you want it to work out, you just need to make certain that you've got the steps in line for that.
I know I want to talk about in a minute investment accounts and those types of things, but one that really caught my eye about 3 months ago was cryptocurrency. I know there's all kinds of apps out there, Coinbase, this particular story that I read was an individual passed away with millions and millions of dollars sitting in Coinbase. And he didn't leave the key. There's like a generated key in order to access the account. So that money's gone forever. If you lose that key digitally, forget it. They're not going to give it to you. It's unique. You have it and only you have it. So I assume that's an important part to consider when we talk about cryptocurrency, not just in an app, but in general, right?
So typical investment accounts have actual dollars in them, and you can set up a beneficiary designation on those accounts pretty easily online, or you can call the bank and you can talk to them there. Cryptocurrency accounts are very unique because they're not actual dollars. They're tied to dollars, but they go up and down based on the dollar value. And those are highly protected. So they generate a key that is personal to you, and it's so private that not even the organization can access that key. So if you lose that key or you don't pass it on to your beneficiaries and your family, then they may be able to get a court order to go and get the access to that money, but they physically cannot do it without that key. You could have all the court orders in the world, but still not be able to access that millions of dollars in currency.
Yeah, I mean, it's funny. The last time we did the virtual town hall, I'm sitting here listening to the three of you speak about planning, and I'm thinking, oh boy, I don't have that done. And again, homework. I have literally a couple $100 in cryptocurrency using an app. And when I read, kind of some of the notes, and you were all going to talk about it, I'm thinking, I'm the only one that has this key. I haven't written it down anywhere. I haven't given it to anyone. It's exactly the same story that I'll read a story and I'm thinking, boy, that's terrible. But I didn't take action until I really realized how it impacts me in terms of, it's a couple $100, but still, the point is that key is unique to you and no one can order that account to be unsealed. And I think that's huge. But you mentioned investment accounts. I assume it's fairly straightforward to name beneficiaries, important part of your estate planning in order to get those in order as well?
Correct. So super important. You don't want your investment account passing through probate. So you can name your trust if you have a trust, or if you don't have a trust, you can just name individuals on it. Most of the time you can go ahead and do that online, but sometimes it's easier to go in person if they have a local branch.
Yeah. So something as simple as movies, online books, online music, obviously same thing, I guess, goes. And if you want to get those to your family and friends when you go on, I assume that matters as well.
Actually, it's a little bit different with those. So it's a tricky thing there. So if you're downloading music or books or something like that, I'm a big reader. Those you're actually purchasing a limited lifetime license for you to use them. Once you pass away, you actually no longer have legal access to those. So you can't pass those along generally over to your family members because that's restricted by their terms and conditions. So you'll have to read the fine print, which I know no one ever does, but generally speaking, you get a lifetime license to go ahead and listen to the music or the TV shows or whatever it is. And you can't actually pass that on because you don't own it.
Interesting as you think about kind of accessing that after either you're sick or ill or your death, and everything's got a password. So Teresa, let me go to you. Is it as easy as just making a list? For example, I have an app where all my passwords are for everything that I have are contained. And is it as easy as that, as making a list or putting them in an app and then making sure that they have access to it? Is that going to do it for me?
The answer is yes and no, because just like Missy said, sometimes it can be incredibly difficult, even if they have your password and login information. So I would say yes, it's always a good decision to have a list, a secure list of your login information so that if something were to happen to you, your family, your loved ones can still know how to access it. But the catch is tech companies are getting more increasingly, protective of their users' private data, right? Data privacy laws are morphing every day and getting more secure. A lot of times, even if you log into somebody else's account, you have to answer a slew of security questions. So I would say, yes, it's a good idea to have that login information, but really, if you want to make it as easy as possible for your family or loved ones later on, I would say do some proactive planning, explore for different social media platforms, what kind of setup they have in place so that you can kind of say, hey, if something were to happen to me, I want these people to be able to control my accounts, and I want this to happen with a proof of death. So there are procedures in place that tech companies are coming up with.
And as you suggest, it is, I think you see these companies, whether they be banks, credit cards, Apple, they all have this two-step authentication, perhaps I've read, or they have another step where I'll enter the password and it's me, and then it'll say I'm going to send you a text to your phone, or I'm going to send an email to your registered email, and you can't still, even though you have the password, you still can't get in it. Apple, for example, they send a 6-digit code to the phone where whoever authorized it. Now, that's, again, the password, as you suggest, I imagine, isn't enough because they've become so much better at multiple layers of preventing fraud, right?
Yeah, and like it makes sense, right? Like tech companies right now, they want to be as safe as possible for their users and emphasize that, hey, whatever you share with us, it's secure and that it's not open to breach. The kind of downside of that, though, for our purposes in terms of planning for after death, is that the onus really is on you to plan ahead of time so that you have settings in place that allow people to access your accounts after.
So are you suggest that our viewers, they check out the individual settings for each account to see if there are things in which they can authorize secondary individuals to access, they can put names on them. Is that something that you would encourage them to do and find out more information?
Absolutely, yes. And then actually later on, I'll talk about with more common platforms like Facebook and Google, kind of what procedures they already have in place.
Yeah, it's interesting because I think I remember we're looking through some of the notes that even email, you have to specifically authorize someone to have access to your email account if that's where maybe the code's going to, right?
Yes, exactly.
Yeah. Then we'll talk a little bit about that. So keep in mind, submit your questions. I know I have a lot. Go to the chat box, go to the Q&A, submit them now. We'll address some of those questions in our second half, which we have about another 30 minutes or so before we get to those. So we'll go. Kevin, let's talk about steps. What can someone do? What should they do in terms of preparing the digital life, after death? What were you recommending that people should do?
Sure. So the first thing that anyone should do is they should just create a comprehensive list of all of those different sorts of assets or bank accounts, email accounts, social media accounts, anything that is stored on the cloud. Also, don't forget about those. There just needs to be a list of all the different assets, and then they need to create a list too of the passwords for each of those assets. And another thing to think about is, like Teresa was just saying, and you as well, how now it's not just you need a password and then you can get in. If you're logging in, maybe you don't have access to the person who passed away to their phone anymore, and that's what they always use to log in. I know, at least for myself, whenever I log in to my banking information, I have to use either my computer or my phone. If I went over and grabbed my sister's computer and tried to log in with that, it won't let me in because I don't use her computer ever, and it'll walk me through a series of security questions. So another thing that people should think about doing is just creating a list of those common security questions. Where'd you go to high school? What's your mother's maiden name? What was your first pet's name? And just having those in there with your passwords will really, really make the process much smoother.
Yeah. Some of these questions, the security questions, they're case sensitive. And I remember I set them up and I can't even remember my own darn security questions because I can't remember, did I capitalize the city in which I was born? Did I spell it out? What did I do? Gosh, digital has complicated our lives when it comes to, the things that preparing for death and what you do. I mean, it becomes so secure and secretive. It's almost too much. One thing that came to mind, Kevin, that really, brought to my attention, which I have this, I like domain names. I actually buy domain names that I see. Oh, I'm going to buy that. See if it's available for 99 cents, and maybe I can sell it later on. I didn't even think about the domain names that I have sitting in GoDaddy. That's important too.
Oh, absolutely. Yes. You gotta, those could be worth a lot more than what you paid for them at the time of your death. And it would be very nice for your wife or children or whoever it is to be able to have access to those. So those are certainly something that you would want to also put in your list of digital assets. And also kind of going along with the domain names, some other things that people might not think about, but I would also suggest having in this list would, if you have a patent on something, or if you have something copyrighted or trademarked, anything like that also that's more digital, I would also include in this list.
So with this list that you create, I'm thinking to myself, it should go in your Go packet. I know if those who watched our last virtual town hall, it should go in this one area where it's accessible. But should you also determine in this list who should have access to them or who should take them and assign those to the individuals?
Sure. So that is something that you could do in your estate plan. You could have we could create a section in your estate plan that has to do with all of your digital assets. And if, for an example, maybe you had a patent on something and one of your sons had helped you and he's an engineer and you wanted him to be the one to pick this up and keep moving forward with it, then in your estate plan, we could create that and say that that was your wish, was to give this patent to him.
Yeah, and actually I'm going to address a question just since we're on the topic that came in from Ingrid, and any three of you or any of you can answer this. The question was whether or not a power of attorney would solve the problem of access, and I'm thinking, I guess it's a two-step process, giving someone the rights, but also giving them the access because they have to have the information. So anyone want to answer that question for Ingrid?
I'll do it.
Yep, Missy.
So a power of attorney is only effective while that person is alive. So once the person passes away, then the power of attorney is no good in effect to access any of their digital information or personal information or make any sort of financial decision for them. While that person is still alive, who created the durable power of attorney, you, for example, are named agent, you can still access those things digitally. You do have rights to that. However, typically, in our durable powers of attorney, we do give access to digital assets. However, you'll have to read the durable power of attorney very carefully because not all law firms do that. So you've got to look at the document itself.
A good point, because I know we've talked about this in a couple virtual town halls ago. Someone, why can't I just go to one of the online sites and just print out my own durable power of attorney because it's cheaper, right? Well, you're going to get what you pay for. And that is exactly what you just said, Missy, because some of them don't actually list out the important things that we're forgetting. They may just give you access to a bank account. And that's it. Well, you're forgetting the digital assets where you have to be very explicit and outline during your life how these things. So the difference in cost is not huge, and it's worth paying a qualified attorney who practices exclusively in this area to do it. So it's a good point. So Kevin, I'm going to go back to you since we addressed Ingrid's question. And again, encourage everyone listening and watching right now, submit the questions, chat box or the Q&A. Love to answer your questions. We got a bunch we're going to get to here shortly. So I mentioned the Go package. Where should people be thinking about putting this information? Where should they have it? Where should they store it, particularly so that it's accessible?
Sure. So the Go package, it needs to be somewhere that is both safe and accessible. So it's kind of walking that line as to where should I put this, that it's, if there is a fire in the home, that it's not going to be burned up and gone, but it still is somewhere where the people who need to get it can know where it is. So one thing that I would suggest is just a firebox. So have that, put it in the coat closet, let the people know that would need it, that it's right there, and then it's safe. Everybody knows where it is, or the people who need it know where it is. Or if you have a safe, let somebody that you trust, give them access to the safe as well and tell them that it's in the safe. And, another thing that people do sometimes is that your freezer, that is fireproof, and, some people put things in there. So even even that's an option. So, and I would also, I would suggest having some copies and maybe having a thumb drive that had it on it as well.
Yeah, my grandmother was famous for that. She kept this little tube of all of her documents in the freezer, and I remember when we went to go get it, after her death, it was frozen shut because I guess it had gotten all wet, and so we had to let it thaw. And we're like, come on, let's hurry this up. Get a hairdryer, thaw this thing out. So it's funny, it is an interesting place and to store things as you think through it. So I know Ingrid asked about, and Missy answered the question about the durable power of attorney and kind of giving access, but now knowing that it's not effective after death, the question is you want an attorney to put, I assume, Kevin, these instructions in some sort of legal document, whether it's in your will, right? You want to give them access and specifically what to do, but maybe you can answer not only what should be in there, but what shouldn't be, in perhaps a will, et cetera.
Sure. So that's a perfect place to be putting in what you want to have happen with these digital assets would be in your will, because that is something that has power after you pass, unlike your power of attorney, which once you have passed on loses all of its power. I feel like I'm saying power a lot, but I can't think of another word to use right there. So yes, but a will would be a great place to have that information put in, or if you had a trust, again, that's a great place too. That's somewhere where we can go in and say, this is exactly what I want to have happen with X, Y, and Z digital asset. And again, we can do that in a trust or a will.
And it's interesting, as I, again, talked about this at the very beginning, about the title, Preparing Your Digital Life for Death. I used to walk or kind of go through Facebook and you'd see people who'd pass away and I'm thinking, oh, someone must be posting for them or they've taken over their account or what happens to their account, right? It lives on forever. I've always told my kids like, hey, whatever you post lives forever. Be careful. So what can you do for those of you or they're watching with, for example, Facebook or Instagram or Twitter? Should you be doing something or how do you protect it or transfer it? Because now I'm wondering how, this happens when people take it over without the password.
With Instagram, I can't recall off the top of my head how that works, but I do know that Facebook has a memorialization process that it can go through to where if you pass away, then Facebook does have a process where you provide a proof of death to them and you can assign basically your legal agent, and then they have access to your account and they create a memorialization page and it says that at the top and it gives that person access to choose which photos are left up and which are taken down, and it also gives that person access, I believe, to accept friend requests still, and I can't remember if it allows them to post still or not. Teresa actually might know a little bit more about this than I do.
Yeah, I was actually just about to step in and help you out there. So for Facebook, you can set up what they call legacy contact. So you kind of go into the settings and you go into memorialization settings and you name specific people that you want to be able to serve as your legacy contacts. So what would happen is after you pass away, this person can notify Facebook about your death and provide a proof of death. And then that legacy contact can get access to your Facebook account and then post a memorialization kind of post and pick out pictures. And it'll just show up at the top of your Facebook page after that. And they can continue to make posts. They can't delete any posts or pictures that you've already posted, and they can't access your Facebook Messenger. So it's not like they can do everything that you can do, but they have access to be able to respond to friend requests, be able to continue to, post annual pictures as like a reminder to everyone, as a way to memorialize.
Yeah, Teresa, does Facebook allow you to, or someone after your death, to deactivate the account, to close it if properly taken care of in the settings or anything like that?
Yes, absolutely. So I guess what I was talking about is the option. If you want to memorialize your Facebook account, that is there for you. But of course, if you set in your memorialization settings saying, hey, after I pass away, I just want this person to be able to close it for me. Or say, hey, after submitting a proof of death, then I just want Facebook to close it out. And Facebook will get those instructions and do that for you. And I know for other settings like Twitter, right now, I don't think they have these like memorialization procedures in place like Facebook and Google might have. And then so their regular procedure saying, hey, as soon as they receive the proof of death, then they just close out that account.
I have a question about Google and the account and how to handle that. But first, I guess the question is, Teresa, we talked about it, about using generic forms online. It sounds to me like this is a great example of how you want to be very specific, maybe in your will or the instructions that, hey, this is what I want done with my online platforms. This is what I want someone to do. Take it down or leave it forever as a memorialization. I assume you can be very specific when you retain an attorney rather than using an online form, right?
Absolutely. So this is the perfect thing to put into your estate plan in to mention or highlight with your estate planning attorney. So you can put it into your will, you can put it into trusts, and obviously powers of attorney for while you're still alive. But for example, you can say, hey, after I pass away with regards to my digital assets, I want to appoint this person, person A, person B, to be able to act on my behalf and do such and such with my whatever accounts.
Right.
And you can be as specific or as vague as possible. You could give them a pretty wide range of discretion if you can't really decide exactly what you want them to do. Or you can be very specific, saying, hey, I want them to close this account, memorialize this account, and whatnot. There is one thing that we would not recommend including in there, though. We would not recommend including those security login information, security questions in your estate planning documents. For obvious reasons, right? Because your beneficiaries, all of them can request a copy of your estate plan, and that means you're just giving out all the security information to everyone who's a beneficiary. And with a will, especially, anything with a will can become public information. So we want to say, specify the people, specify your instructions, but don't get so detailed that you're putting in your security login information.
So it brings up a question that was submitted. That is, you said don't include the passwords and those security questions in your public documents like wills and trusts. So who do you give that to? Who do you give access? That was a question submitted. Where do you store those passwords? Who should have them? Is it an attorney, a family member, a friend? What do you think is the best?
I think it kind of goes to what Kevin was saying earlier, right? It's walking the fine line between make sure it's someplace safe, but you definitely want it to be accessible. So I think just have a sheet of information that you store with your Go package in someplace safe so that if something were to happen to you, your trustee, your executor, they can access that and see whatever access that they need in order to open and close out any digital assets you have.
And I do think you have to think about this now. I mean, COVID has made us think about everything in a different way. And we're focusing a lot on death, right? And you say, well, give it to a trustee. But I do see, and from experience, I had someone who was in the hospital and we were trying to guess her password because we needed to get into her bank account to pay some bills. I guess that person, you should give it to someone different in the event. Let's just say, gosh, here we are, hospitalizations are going up. Here comes winter. We know that sickness increases at certain age above 50 for people during the winter and holiday season. I imagine the recommendation is, okay, here's my passwords for my financial and banking and other things to a trusted friend, that in case something were to happen, you would recommend that as well, Teresa?
Yeah, so that kind of goes in line with any instructions that you have in your power of attorney, saying, hey, my power of attorney has the authority to, access my online accounts for me, and making sure that that's an explicit statement in your power of attorney.
Got it. So Google, talking about email. You mentioned something about an account manager. What should people be thinking about and looking for if they have a Google email in terms of making selections and settings to kind of prepare that digital account?
Absolutely. So unlike Facebook, Google kind of operates on a more passive approach, right? Like Facebook lets you pick this person and have all these proactive memorialization settings that you can set up ahead of time. But Google essentially operates off of an inactivity principle. So you can go into your Google account settings and say, hey, if I don't use my account for a period of, I don't know, some people say 3 months, it can go up to 3 years, but you can say, if I don't use my account for this period of time, there's no activity at all, then it triggers Google to send that information out to people that you list out. So you can say, hey, I want friend A, family member B to get notice when there's an inactivity. And then so when the period of inactivity lapses, then Google will text your contacts and say, hey, this person's activity is inactive, and based on their settings, you now have access to help them manage this for 3 months. And you can be very specific. You know how Google offers a whole suite of services, their Google Photos, Google Email, Google Drive, all those things. So you can say, hey, I only want my contacts to have access to my Google Email, my Google Photos. Or you can give them the whole suite access to. So that's kind of how Google handles it.
Yeah, I think that's a thing that I didn't even think about, you know, that I've got these email accounts that in the event I pass away, it's the last thing I thought about. And that's why I think when I read the title today, I was trying to grasp what this was about and why it was important. And now the more I dig into it, it really makes me think I've got to have a conversation with an attorney to kind of give me a checklist, and I can, you know, check them off that I did that, and feel confident that I'm prepared, that, you know, that everything's taken care of. It is almost, I refer to peace of mind, because there's so much to think about, especially as complicated as our lives have become with digital, that I think that's a good point to raise. So keep in mind, submit your questions right now to the chat box or in the Q&A. We're going to start answering some of the questions that we have that have been submitted already. We'll get through those, and obviously you have questions along the way, submit those. Otherwise, you can go to tuckerallen.com/questions. You could submit those then. We'll address those at our Facebook Live, which we do every Friday at 1 o'clock. Or we'll do, again, the next virtual town hall, we'll address those during this as we schedule it moving forward, including the Zoom that we have coming up for our Kansas City metropolitan area. Make sure to go to tuckerallen.com. You can register for that in the Kansas City area, as well as the seat list will be held live, making sure that we can go ahead and have you attend with confidence, being compliant with CDC guidelines, and making sure we're sanitizing that room for you. So check it out. Those 2 seminars coming up here in November, tuckerallen.com. So let's go ahead and get to some of the questions, and we'll toss them around and see if we can answer them for you. So Virginia has a question. I'm going to go to Missy. It says, we have a living will, a revocable trust, and other documents which are on paper. How will the digital era impact this?
So it's great that they're on paper. That's the most enforceable way to have them, is actual ink on paper. What I would recommend doing is to go and get those scanned. If you don't have the capacity to scan, maybe one of your friends or relatives does, or you can even take it up to like Kinko's and scan it in there. That way you've got an electronic version in case something happens, and you've still got the paper version.
Yeah, I think it's so, you know, I had my original will and trust done 26 years ago. And then as I've always said in the virtual town hall, I'm a client of TuckerAllen. And I was glad and surprised to see I got sent to me all of my estate planning on a thumb drive. Love it. I remember thinking I had my original documents still in paper, sitting somewhere in a safe, and I'm thinking, gosh, you know, I didn't make sure nothing spills on it and keeping them in order and the pages don't rip. But yeah, absolutely. I mean, take advantage of this digital era, put it on a thumb drive and store that in a fireproof safe in the Go packet. I love it. It's great. If you don't have that, you need to demand it and make sure you get it done. So that's a good point. So good question, Virginia. So Kevin, Michael says, what is the process for my heirs to cancel my social media accounts? And how soon should this be done after my death? Both if my wife survives me and when we both die. So it's kind of a faceted question. So maybe let's start with, what's the process to cancel social media accounts first?
Sure. So I know that we kind of touched a little bit on Facebook with Teresa a minute ago. So that's kind of the process for Facebook. And, you know, it's up to Michael. Would he like to have one of those legacy accounts on Facebook still? And if he does, then that would be something that he should put into his estate plan and say, this is what I would like. I would like to have this legacy account, and I would like it to have these photos and this sort of things. As far as other social media accounts, I'm not quite sure what other social media accounts he has, but if it's Instagram or Twitter, I'm sure that they have their own process of dealing with that. And then there's going to be more social media accounts popping up all the time and different sorts of things like that, and they'll all have their own way of doing it. My biggest suggestion to Michael would just be to go in there, look at the settings that each one of these social media, what they provide, and once he finds that out, then can move on from there to decide what his wishes will be, especially if they do provide something like that legacy account.
I think that's the wonderful thing, Michael, and for everyone watching, and that is, again, I've talked about these forms online. When you hire someone qualified who practices exclusively in this area, the plan is individualized. And that's the wonderful thing, Michael. You can go in there and individualize what you want to happen, when you want it to happen, as soon as you want it to happen with regards to social media accounts. Direct those, your trustee or those people who will take advantage of what you want done. Something that likely is not going to happen with a form you download. It won't have that provision. You won't have the guidance in order what to do. And that's why I felt like this topic was so interesting, that allows people to take it another step further and really complete and have the peace of mind and the confidence when you're done that everything's taken care of, that all the questions that I would never have thought about. I would honestly never have thought about social media. I would never have thought about airline miles or credit card points and what to do with those. It's just kind of they're sitting way back there. I mean, when I'm alive, absolutely I'm thinking about them, but I'm not thinking about what happens after I pass away or after I get sick. So good question, Michael. All right, let's go. Gerald, let's go to Teresa. Why should I set up a trust instead of a transfer on death or beneficiary? So that's a question from Gerald.
So that's a really good question, and one that we get pretty often. And I guess the simplest answer is a trust is just a much more efficient process to keep track of all of your assets. So for example, for your beneficiary designations on your different assets, you have to go into each institution and say, hey, I want to set up my beneficiary for bank account A, I want to set up my beneficiary for investment account B. And if you have multiple assets, even if it's just more than just 3 or 4, that can be kind of a headache to have to go back and update the beneficiary designations every time you wish to make a change or something happens. Whereas when you create a trust, you do it once, right? You set up the trust as the beneficiary on these different accounts. And if you want to make a change later on, you just make a change to your trust. It's a lot more efficient. It's consolidated that way.
And I know this is a repeat question, and we get it every time we have these, and it goes in line, Teresa, with this question about setting up a trust. I mean, people think, one, I got to have a lot of things. I got to have real estate. I got to have a ton. I mean, there's a level of money that I should have before I should even think about a trust. That is a falsehood, isn't it? I mean, everyone could benefit from having a trust, right? No matter what you have.
Yes. So yeah, that's a common myth that we have to bust all the time. We definitely recommend trusts for most people that walk in here because yes, you have some homework to set up to make the trust a beneficiary, but it really gives that fuller peace of mind.
And it's interesting how, as we've progressed in society and we moved on 15, 20 years ago, people wouldn't necessarily talk about the trust. My wife was just at the DMV titling a new car, and the person there, young, probably in their 20s, said, hey, are you going to put this in your trust? Didn't know we had one, but asked, and my wife's like, oh my gosh, we do have a trust. I've got to put this in my trust. So, and you know, you don't have to have a ton of things, and it's as simple as those items. And it was really a great question that this, you know, young 20-something person is reminding individuals to put it in their trust, things that you overlook. And so I think that's great. Now, Teresa, I'm just going to come back to you because a question along these lines just came in and might as well ask it. What's the difference between a will and a trust?
Well, the biggest difference is that a trust is actually probate avoidant, right? A lot of times people think a will is enough. But really, I like to think of a will as just an instruction sheet to your probate judge. If assets have to go through probate, that's what your will is there for. It's to kind of direct what your wishes are with regards to probate assets. And most of the time, people come in because they don't want to have to deal with probate. So that's why they normally use trusts, because when you do your homework and you title your different assets with your trust, then those assets don't have to go through that probate process.
It's kind of like going just half the way. You know, like you're already committed to doing something. I'm going to get a will done, but you haven't gone all the way down the road. I mean, you might as well finish, you know, or I'm going to go on vacation. I'm going to go look at the mountains, but I'm going to stay 500 miles away and see them from a distance. I mean, let's just go all the way to the mountain and get a good view. So if you're going to do a will, get the trust done. Because the point is if you're doing a will, you want to transfer your assets. I want to avoid probate. I don't want to hire another lawyer or my estate to pay money for a lawyer and a judge who doesn't know me to distribute the things that I really want distributed. So I might as well go the full distance and do the trust, right?
Exactly.
Right. So Missy, the question is there a way to keep your data on computers and hard drives to only be accessed by certain individuals upon death?
So that's a little bit tricky if there are actual physical things that you want to control access to. So your computer itself, if you want only certain people to access your computer, the always easy way to do that is to create a password on your computer and only share that password with the certain people that you trust. However, if they can't access your computer or you don't have a password on it, then things kind of get up in the air. They might have to take it to tech support. They might have to get a court order. It can get really messy really fast. So put a password on it and share that password with people you trust.
Yeah. All right. Let's go. Kevin, let me ask you this real quickly here. Should I put my passwords in my safe deposit box? Only trusted people will have access to it. And that's from Marnie.
Sure, that's not a bad place to keep a list. Like I was talking about earlier, we want to have this list that has your digital assets and your passwords with some of those security questions. We want to have those all somewhere compiled in a Go package or whatever it is. Again, a safety deposit box, those make me nervous sometimes just because banks don't always like to just be letting anyone access those. Whoever these people are, that they need to be, I would want to know 100% that they had access to it and not just you've told them that they have access to it. So I would want to know that the bank is going to allow them access.
Yeah. Agreed. I'd give them, I mean, go get a fireproof safe, give them the passcode that they can access or a key. I know some of these are like, for example, I have a thumbprint safe, but it also has a key. So I've given the key to someone I trust that, hey, if something happens, you can access and the documents are in there. So I think it's a good idea. All right, that's from Marnie. So let's go, Teresa. Here's a question. This is from Dennis. I'm hoping to learn more about setting up trusts for our children and grandchildren. They are beneficiaries of our trust, but rather not just give them everything on day one. So the question, I guess, from Dennis is, hey, what can I do to kind of spread out perhaps the distribution of the trust for their children and grandchildren at certain levels?
Yeah, so the good thing about trusts, especially if he has a revocable trust, is that those can be updated. So if you have it set up right now where grandchildren or children, they're just getting something, one lump sum outright, that's easier administration for your trustee. So that might not be a bad thing, but if you are pretty adamant on spacing it out, we can definitely change the distribution structure and update your trust that way. To say, hey, maybe for my grandkids, I want them to get a fraction of their portion of their share at this age, another fraction of their share at a certain age, and then intervals like that. So.
And that's something that trustee handles, or as it goes along, whether 24 or 31, whatever an age range you pick, and they distribute it at those dates.
Yes. So I would say one of the downsides that you want to be aware of when you do this spacing out option is that, yes, that just means your trustee has to manage this trust for longer to make sure, hey, the youngest beneficiary reaches that last age point for that final distribution. And then the longer that the trust is held out for, that's just more years of administrative work and potentially administrative costs for the trustee.
And I assume the value of the assets would come into play as well in terms of, making sure that those are distributed and taking into consideration tax ramifications for Dennis and those things.
Exactly. So I wouldn't say it's definitely not one size fits all. Sometimes based on the amount of assets that are in the trust, it makes sense to hold it out for longer and to space it out this way. It really depends on your asset portfolio and then what our recommendation would be about whether it might be more beneficial to do it just one lump sum, or maybe it's makes more sense to space it out.
Great. Kevin, I'm going to ask you this question from Karen. Again, multiple part question. Karen says that her mom has a revocable living trust. Karen's brother is listed as the first trustee in the event of her death. Karen is the second. If he no longer wishes to be her trustee, can Karen legally act in that role, or do we have to have it revised? Or what happens if the brother no longer wants to act as trustee?
Sure. So if the brother, if he is set up as the successor trustee after mom and he passes away, or he just has a lot going on in his life at that time and doesn't want to take on the duty of being the trustee, then it's automatically going to drop down to that next person in line to be the next successor, who would be Karen. And so once it drops down to her, then she's the trustee at that point. There is no need to have anything revised or anything like that. She has just become the trustee.
Great. So as we continue, we're getting close to ending the segment, but we have a few more questions that come in. If you have questions before the end of the virtual town hall, submit those now via the chat box or the Q&A. We'll get to those again. Otherwise, you can submit them to tuckerallen.com/questions. So Missy, let me get to you this question from B. How do I accomplish renaming my portion of a partnership to be own titled in my trust? What steps should I take to accomplish this?
So that kind of depends upon what sort of corporate structure your partnership has. Is it an LLC, an LLP, an LP? There are all kinds of different ways to do it. Generally speaking, you're going to want to change the operating agreement for your share of the business to have transfer upon your death. Whoever you name, it could be your trust, it could be another beneficiary. It might end up being a buy-sell agreement if you have a large business going on. And there might be insurance policies to cover that sort of thing. So really it depends upon your situation, but the general rule of thumb is update the operating agreement.
Great. All right, Teresa, Douglas has a question for you. Douglas says, how do I protect my home and equity from long-term care expenses for me or my spouse? And I know we've talked a lot about this. We talked a little bit about it in the Facebook Live section, which I know we'll do again. So if you want to hear more about this, tune in every Friday at 1 o'clock. But so Douglas says, how do I protect my home and equity from long-term care expenses?
I'll try to keep this as short as possible because I can talk a really long time about this. But essentially, this ventures into the elder law portion of our work, right? It's beyond kind of that basic estate planning of regular wills and trusts. So when we think about asset preservation or asset protection with regards to long-term care expenses, we start thinking about other instruments such as irrevocable trusts. And really, it depends on your circumstances about how much time do you think you have before you need to access long-term care. Depending on that kind of projection that we can play with, we can set up an asset protection trust. And an asset protection trust, it's irrevocable, but the benefit of that is for you and your spouse, any assets that you put in there, even though you're kind of giving up your ownership of it into this irrevocable trust, it's like a lockbox. But you can set a trustee, somebody other than yourselves, to be the trustee of this lockbox. And those assets can be preserved for your beneficiaries and can be protected from long-term care costs, given that you have enough time before you need long-term care. If you don't think you have enough time, and normally we're thinking a 5-year period, that's a look-back period. If you don't think you have the 5 years, then we have other strategies to see what we can kind of scrounge up to save for your beneficiaries. But that one gets even more kind of customized depending on your situation.
Yeah, it is a very, when we talk about elder law, I was never, and it's still, I'm not a fan of the word elder law because it doesn't really tell me. It's very similar to this topic, like what does the digital life after death mean? What does elder law mean? I mean, at the point, I love the asset preservation or protection, the wealth preservation. I think that's very descriptive. And I would encourage people to go to the website to learn more. There's a lot of videos and video content on the website, TuckerAllen.com, that talks about this. Set up an appointment with an attorney that talks about, long-term care, because as we know, we get older. Those are the things that inevitably may or may not happen. And you want to make sure you preserve what you have and that it can go to the people that you want. and you need to take action well in advance to make sure you give yourself the best opportunity to do that. So get more information and check out the website. I think it's a really interesting topic, as we mentioned, elder law. Let's see, question came in here. Let's go to Kevin. This is from Stephen. Stephen says, we set up our trust. Since that time, we purchased rental property. Our question is, should we have the deed read the trust as the recipient in case of death, or should the rental property be titled in the trust?
Sure. So there's a little bit more information that I would love to know from Steve to answer this comprehensively. But kind of what I can say with what I know about this is that, maybe an LLC would be something to think about instead of just naming it straight into the trust. So if an LLC hasn't been created, that might be a good idea to do. And then once you have that LLC, you can make that TOD from there to the trust upon your death. So I would shy away a little bit from just titling it straight into the trust, just because we want to have that limited liability that the LLC provides us. And I know that people do have liability insurance and all sorts of things like that. But again, on my end, I just want to see the most amount of coverage possible, and that's going to occur with an LLC.
It's an interesting as you think about it, because I assume, Kevin, what you're suggesting is in the event of something were to happen, since it's a rental property, right? And you're getting people that accidents happen, injuries, slips and falls, whatever, putting it in the trust, I know we're getting in the weeds here, that exposes the trust assets to pay for perhaps liability or damages or something like that if you just dump it in the trust?
Sure. I think that could definitely be a potential. If you just put it straight into the trust, I would say that there's a pretty good chance that if something were to occur and it was major enough that whatever liability insurance you had didn't cover it, then I think that there's a good potential this person could go after the other assets that were also in the trust if it wasn't named as an LLC. If they went out and created this LLC, which is it's a fairly painless process. It's not a difficult thing to do. And what LLC stands for is a limited liability company. So what this does is whenever you fund this LLC with whatever property, there's a few things that you have to do, but it's nothing major or hard at all. So once you fund this LLC, as long as it's not underfunded and it provides the liability coverage that you're looking for. It makes it to where if something were to occur, then the LLC could get taken from you, but that would be it. So it's not going to be your whole trust or trust assets or anything like that.
And Missy, I saw you shaking your head. And I have a question that just came in for you, but I'll let you kind of follow up as well. I saw you shaking your head.
Kevin did great on that question. It was a really good one. The one thing people typically forget about with rental properties is they've got their landlord's insurance and they think they're good to go, but it doesn't actually protect you against intentional acts, which would be something like they allege discrimination against them on the basis of race or gender or the fact that they have kids. And those things your liability insurance isn't going to cover, and you need to put into an LLC for that protection. But otherwise, Kevin did a fabulous job answering that one.
So Mike, I'm going to just stay with you, Missy. Mike has a question, similar we've been talking about here. Mike just purchased a retirement home in Florida. How does Mike get this entered into the trust? Because it seems like it's not a rental property, it's personal use. So how does Mike get this into the trust?
So it's actually very simple. He'll need to get an attorney to do a deed and record it in the local recorder of deeds office in that county. So your trust can be a Missouri trust and can control what's going to happen to that retirement property, but you need to have someone licensed in Florida to actually do the deed transfer into the trust for you. Now, if you're a client here, we can refer you to someone down there that does a great job for it. But ultimately, you need a Florida attorney to handle a Florida property to put it into the trust.
And it's not complicated, or is it complicated if it's encumbered by a mortgage? Is the lender come into play with that, or is it fairly straightforward?
So it does get a little bit more complicated, but it's pretty straightforward once we know what the situation is. So if there's no mortgage on the property, then you can put it directly into your trust. If there is a mortgage and you think you're going to end up refinancing soon, then you might want to keep it in your own name because the trust has no credit history, so you can't refinance in the trust's name. Yep. So there's a little discussion on that one, but it's pretty straightforward once we know your goals and what you're going to do with the property.
All right. Teresa, last question for our virtual town hall comes from Carol, who's a happy TuckerAllen client. Thanks, Carol, for your trust in TuckerAllen and your confidence in them. And Carol really just wants to follow up on, do we have a worksheet that we can use and we can send to Carol to organize digital estate planning? And if not, what I would maybe just suggest Carol reach out, give us a call, and we'll get something to her, right?
Yes. So Carol, if you have any questions on that, feel free to reach out and we can help set up an organization sheet for you.
Yeah, of course. Not charging you, just give us a call. Thanks for being a client, and we'll get that to you. And it's something we maybe consider posting on our website too. We'll take a look at that and see if we can give that to people and help them get started on preparing their digital life for death, which a very interesting topic. So thanks to the panel for joining us. I appreciate everyone's comments and their thoughts and process on this. Appreciate it. So tune in to our Facebook Live on Fridays at 1 o'clock. We'll bring to you things just like this, but in a very, very condensed format, 15 minutes. We'll answer questions that are submitted in the comment section on Facebook Live. Go to the TuckerAllen Facebook page. Follow us for more information. Keep on the lookout for the seminar coming up here in November in the St. Louis area, as I mentioned, as well as the Kansas City metropolitan area. You can go to TuckerAllen.com. You're going to need to register because we want to make sure we limit the attendance for the in-person, but you can go ahead and register for the Zoom. That's the one in Kansas City for that metropolitan area as well. Get more information on there. You can also find more information and resources at TuckerAllen.com. If you'd like a consultation, or you have a lot of questions you want to follow up with, you can give them a call at 866-335-3375. Again, or you can schedule an appointment online by just going to the website at TuckerAllen.com. It'll walk you through and get you taken care of. So continue to tune in for more information. We'll continue to bring you the TuckerAllen panel of attorneys to bring the resources and information and answer the questions that you have. Thanks for joining today. Have a great rest of the week, and until next time, see you then.